Good morning, everybody. Good morning. I love the enthusiasm, the energy, the chatter. I love it. Thank you, everybody. Welcome to our OACS meeting for the month of April. I always feel so energized when I come into the room. I just feel the energy filling the room, the enthusiasm. Love it. Thank you so much. Just a reminder that, again, we have flyers on the tables for next month's meeting to make it easy for you to share that information. And again, thank you, Serpa. Just a reminder, I'm just going to keep preaching from the pulpit. We are just so enthusiastic about trying to get the message out to our community of who we are and why we're here to serve our community. And that is to be a resource to the seniors in our community and their adult children. For any of you that don't know, I'm a real estate agent. Maybe some of you don't know that. And yesterday I met with an adult child. His mother was in the home. She was on oxygen. And he's looking into having to move her into private care. The family's having to come together and look at what they're going to do with her real estate asset. And so to be able to come into that situation and just support them, right? Just to be able to hold their hand, assure them everything's going to be okay. They're in the hands of a capable and knowledgeable expert who can assist them and their family. Any resources that they need, I have them available. So that's what this networking is all about, is being able to, when we're interacting with either a senior or one of their adult children, being able to assure them, hey, I know a lot of people that can help you, and we're here to support you. So again, just continue to support our social media. That's how we're going to get our mission and our vision out there of who we are. And so to remind those of you who've been coming faithfully or anybody who's new, what our mission and our vision is. Our mission is to proactively serve and educate each other in pursuit of synergistic solutions for seniors and their adult children. Our vision is to create a unified senior resource team to support each other and the community that we serve. And our values are integrity, synergy, service, and collaboration. And again, a reminder, we have the QR code on our poster out front. If you haven't joined our Facebook page, shame on you. And but we've got a QR code to make it super easy. And then, of course, you can find us on Facebook. And then also Serpa brought up the basket for all of these amazing raffle prizes. If anybody forgot to put their card in, don't be shy. Run up and put it in there. You will regret if you don't do it. All right. Anybody here today new? Just raise your hand. Welcome. Oh my word. I get sure. Well, raise your hands again. Let's count. 1, 2, 3, 4, 5, 6. Wow. So good. Oh, that's so exciting. Okay, so after the meeting, everybody make sure to say hello to our new visitors and make sure to, well, if you've put your card in here, we'll have your information. We'll get you on our email list. Make sure to get you on our directory as well. So our Facebook count, we are up by 8 people, baby steps, 404 people. The goal for 2024 is to get to that 500 mark. And let's open it up for anybody who has any announcements of any upcoming events. Just raise your hand. If you're a loud talker, just shout it. If you need the microphone, I'll bring it to you. Don't be shy. Nothing? Shelly? And according to the Social Security office, if you get a check or you know somebody who gets one and it's supposed to be deposited on the 3rd, if it's more than 2 days late, they need to notify their bank first, then go down to Social Security and make sure that while they're there, even though it's the worst thing to do, go down to Social Security, make them change it to anybody who has a Wow. Yes, so thank you for that reminder, Shelley. And you need to book a presentation. All right, anybody else? Yes. Yay, love that. And you just made an idea pop into my head. You know, you guys, when you have these events, post on social media on our page, right? Do a Facebook Live, do a video, post these events. I think that would just be really great content showing, you know, the action really happening versus just the flyer on our page, like actual events happening real lifetime. So great. Any other announcements? Okay. So if you have any information you want to get on our Facebook page, we have Anna Felix over here. She can collect that information. She's been doing a really wonderful job of hosting and managing our Facebook page. Thank you so much. And I'm so I just want to do cartwheels. We have no more space left for 2024 for our speakers. We are all booked up. So yeah. So start booking your spots for 2025, Shelley. Oh, I love her. All right. So we are so excited today. We have with us Jeff Bean of Borton Petrini. He's going to be speaking to us about legal considerations for the elderly, what legal actions should be considered to preserve the elders' use and control of their property and to make decisions on where to live. Let's give him a warm welcome.
Well, thank you. This is my pleasure to be here. First off, I think that title I think is a little bit long. We probably ought to cut it down shorter next time. So, hopefully you can hear me. I'm Jeff Bean. As you said, I'm with the law firm of Borton Petrini, where the firm's been around for about 110 years. We have about 8 offices throughout the Central Valley area, going all the way from San Diego all the way up to Sacramento. I'm responsible for the estate type of actions that are going on. So anything that deals with trusts or conservatorships or with probate or some litigation in those areas, that's what I'm involved with. So let's see, I think there we are. Okay. I also do estate planning, various documents like that. So I've been here in Modesto for about 15 years, and before that, I used to work over at Lawrence Livermore Laboratory. So I'm used to dealing with all kind of complex type of contracts and different things like that. So that's a little bit about me. I want to talk today about how we can preserve the assets, or what are some of the different considerations that you need to be taking in regards to elderly individuals. In my experience, in the times that I've been practicing, I find that as an individual is getting towards the end of his life, he or her, that there are issues that come up on trying to deal with the assets, on that they're needing to have assistance in it, and whether it's going to be family members or a friend or something, or even themselves, that there are issues that come up that they need assistance in trying to deal with these assets and figuring out what's going on. So that's the question that I wanted to pose. You know, how do we deal? What are the different things that we need to be dealing with? What are the legal issues that we need to be trying to address? Now, I'm going to be addressing this based on various, well, first off, okay, this is going to be different for every individual. It's going to be depending upon whether you're married or whether you're single or whether you have your competency level that's going on for the individual, Or sometimes the family dynamics, are they from a blended family? In which case, then there are stepchildren that have issues with the step parent. What are the type of assets that you're talking about? How many of the assets are you dealing with? Also, the trust or the confidence of the family. How confident are you that your children or your spouse or whoever will be able to fulfill the intentions that you have in managing your assets? Okay. So I'm going to be presenting this as more through scenarios. I'm going to give 3 different scenarios, and we can go through those different things. This is not all inclusive as far as for the answers, but it's going to help you to prompt to think, oh yeah, I can remember these type of experiences, and this is maybe possible ways that we can address those things. It's just a guidance. It's general, and it's based on experiences that I have seen in my practice that's going on. So the first scenario, happy couple. Okay, you've got a husband and wife that are married. They have several children. Their objective basically is they want to provide for the other spouse when one of them passes away. And then they want to have all of the assets to be going to the children when both of them have gone. However, they don't have an estate plan. An estate plan meaning that they don't have a will, they don't have a trust, they don't have any other documents to assess it. Now, I saw a statistic once that says 80% of the population fall into that category where they don't have a will or a trust or anything that's directing on how the assets are to be going. So if your clients or your people are falling into this category, they're same, they're right in there with everyone else. The law will prescribe on how these assets are to be divided out. So let's go through this first scenario. Okay, the wife dies. Okay, you have this happy couple. You've seen what their intents are, but the wife now passes away. Okay, in this type of a scenario, okay, typically they'll have a house. That house will be under what's called a joint tenancy. And what that means is that upon the death of the first person, the first joint tenant, that property will automatically transfer over to the surviving spouse. Okay, great. The husband gets that property if the wife has passed away. Same thing with bank accounts. A lot of time in bank accounts, you have joint accounts that are there. When one spouse passes away, the surviving spouse gets it. So in this case, the husband's going to get the bank account. IRAs or 401ks, anything that in those times it's a contract. Under that contract, you identify who is going to be the beneficiary. Okay, in this scenario, all right, the wife passes away, the husband's going to be receiving all those assets. Anything that is community property. Community property is defined as those assets that are acquired during the marriage, that is not a gift or not an inheritance. Okay, those under the law, community property will transfer if there's no will, like in this case, there's no will, then that property will then transfer over to the surviving spouse as a community property asset. Separate property are all those things that have been acquired prior to the marriage or have been received as a gift or as an inheritance. In that case, 1/3 of the asset will be going to the husband, and the other 2/3 will be going to the children. Now that will have to go through a probate type of action to be going through. Now, the concerns that occur. What happens if the husband, after the death of the first spouse, remarries? What's going to happen with the property? Because all of the assets are being held by the husband, he can do whatever he wants with the property. So he can, after he remarries, first off, when he remarries, if he dies without a will or a trust or anything like that, at a minimum, the surviving spouse will get 1/3 of the entire estate. If he has a will, then it'll be going according to what the will states. But the husband can then gift out the assets or add the new spouse onto any of these things, such as the joint account or such as the property. And that happens quite often where the husband feels as though that they need to be helping, or that it's the right thing to add the spouse onto the property. Okay. But in which case, then the problem can be is that all of the assets that were there at the time of the first wife to pass away can be distributed out to the other spouse or to their children or to other things. And so they can end up in a scenario where the children receive nothing. So what do you do in those types of situations? Okay, to help to protect you as, if you're the wife, you're wanting to make sure that those assets are going to be going to your children eventually. First, you want your husband to be provided for, but you want to make sure at least your assets, part of your assets are going to be going to the children. So the way we address this is by having a trust. Under the trust, then, the assets are transferred over to the trust, and there's specific instructions in there which says that at least as to half of the property, that half is going to be held for, yes, the benefit of the husband, but can only be used for what's called the health, education, and welfare of that individual, of the surviving spouse. And he has to use his other half before he can start invading the portion that would belong to the wife. At which time then, at least half of the assets then are preserved for the children. The husband can't gift those out. He can't transfer them away. Yes, he's being provided for, but they can't be given out to this new spouse or to the other children of the other spouse. Scenario 2. Okay. Husband and wife are married with several adult children. Wife develops dementia. You've seen this a lot. Or Alzheimer's, or has a stroke, or there's other issues that go on. The husband is unable to further care for the wife. That's the scenario I think that you were just addressing, where they can't provide for the needs. The husband, the income of both the husband and wife it's insufficient for them to be paying for assisted living. Yet their only asset that they have is that of a house. Okay, what do you do? How do you then provide for the benefit of both meeting the needs for the wife who has dementia, but also for the husband who is getting elderly and can't provide for the wife? Okay, the children usually will step in, and they usually have an objective that they want to relieve the husband from financial stress. They want to help them out. They want to help to provide personal care for the wife. And a lot of times the children are the ones who are saying that let's try to get them into an assisted living facility or be providing people to come into the house. But we need to have these assets. We need to get the money. There's not enough money here, so we need to be doing something to be able to get this. Now, the problem is, as you've seen, those people who are realtors in here, how do you sell the house? If the wife is on the title, she can't, and she's incompetent, she has dementia, she can't sign the documents to transfer the house because both the husband and wife are on the title. Okay, so what do you do? Solutions. Well, you can have a durable power of attorney. A durable power of attorney it's a document where you have granted that right to make decisions over property to another individual. I can tell someone that I want them to go buy a house for me. I want them to go to Manteca and buy this house. And they are able to sign the documents. And I give them a document that says, you now have that authority to buy this house. That's called a power of attorney. A durable power of attorney just means that it is effective once you become incompetent. Once a doctor says that you're no longer able to make decisions for yourself, then that power of attorney is effective and you can make it. It grants the right to an individual to then have that authority to sign for the sale of houses. Now, powers of attorney are very specific. You've got to have that authority granted in the power of attorney to be able to sell assets. And for the most part, a durable power of attorney they will include a lot of different powers, and it includes usually that right to be able to sell property. With that, then you take that and you go to the escrow agent. The escrow, the title company will then say, okay, yes, they confirm that you have that authority, and then they'll allow the person who has that authority to sign it. Now, these can only be created when you are competent. So you have to have some pre-planning to do this. You have had to granted this authority out prior to before you have this dementia issue. Another solution you can do to transfer the property. If the property is put into a trust, okay, that way a trustee is holding the property. It's no longer, technically, it's no longer in your name, but the trustee is holding it. Now, we have what's called revocable trusts, meaning that the same person is creating the trust, the same person is the benefit of the trust, and the same person is the trustee, is in control of the trust. This is what we normally have all the time. But the idea here is that you have taken the property, you've transferred it out of your name, and you've put it into a trust where a trustee is now holding that property. Then that trustee has the authority to sell the property, to transfer it, to sell it, buy something else, or to be using the things. Now, a trustee is under specific duties and responsibilities of using that property for the benefit, or as it's described in the trust, on how those assets for the benefit of the settlers, the ones who created the trust. And then when both of the settlers have passed away, to taking that asset and distributing it out according to what the trust says to the various beneficiaries. However, this requires, again, some pre-planning. You need to get this in place before the person becomes incompetent or not able to make those decisions. Okay. If you come to the scenario where the person is incompetent, they have dementia, they're on titles for these different properties, then the only way that you can get this property transferred is by taking those rights away from the individual. We do this legally through what's called a conservatorship. Under a conservatorship, you're going before the court, and it has to be shown that this person is no longer competent, cannot make decisions, and someone is then petitioning to be appointed to have that right to make decisions for this individual. A conservatorship can, as I mentioned, takes away the rights of the individual, and it takes about 4 to 6 months for a conservatorship to go through, and cost generally between $3,000 and $4,000 to try to do. So that's a longer process, but it can be done. You can get it done. You can transfer the property, but it's not going to be something that's going to be right away. It's much easier if you've pre-planned and had a power of attorney or have had a trust. So, third scenario. Okay, I call it controlling children. Okay, we've all seen this. Okay, in this scenario, we have a mother and several children. Okay, the mother is needing, okay, the father's passed away or whatever. So you've got the mother and several children. A mother is needing to have some limited assistance. She's getting it more, it's becoming harder for her to get around. She's needing help to cleaning up the house, doing different things. One child will then volunteer, says, hey, I can stay with mom. I can be of assistance. I can be providing the cooking and the cleaning and the care. I can transport her to the doctors and doing different things like this. I can help her pay the bills. As the mother then ages and becomes more and more dependent upon the individual, she sometimes will get more and more confused, or the other children will perceive that. A lot of times in these circumstances, the other children are then questioning, what are you doing with mother? Why are you using these assets in this way? How come you're spending it? Why are you getting, buying these different things? I want to know what's going on with mother and her accounts. And the child will then start, the one who's staying there with the child will start limiting the access that the other children will have. Because they don't want to have this frustration or this confrontation that's going on, or the questioning that's going on by the other children. Now, the other children are just trying to look out for the interest of the mother. Yet the child who's been living there, usually for years, has been there for years. They've had a scenario where they've always been able to take actions this way. The mother's always approved the different transactions or different purchasing of different actions. And so all of a sudden they're being questioned. The concerns of the children is that caring for the mother, that the one who's caring for the mother is taking advantage of the mother. That the child is unduly influencing the mother. She's living right there with them. She's caring for them. And so she's maybe persuading her to change different actions in, with her assets or her will or her trust. And so the perception that the other children outside is that they're being unduly influenced, and that I'm not going to get my share, basically, of the estate, or it's not there to be providing for the mother. The mother may revise her will, may revise her trust. They may take a lot of different actions that will then benefit this child. And the child will say, well, that's what she wanted. She wanted this too. She wanted me to receive the house because I've been here taking care of her all this time, or whatever other examples. And those are very hard situations that tears families apart. So some of the difficulties that are faced in this case, in this type of a scenario, is that the question is, who has the right to control the property? Is it the children? Is it the child? Well, unfortunately, it's still the mother. As long as she's competent, as long as she's determined, and the presumption is that an individual is competent. As long as she's competent, she has the exclusive right to decide how her assets are going to be distributed or managed or controlled. She may transfer the bank accounts over to the child who's taking care of her. That's her right. She may transfer the house over to the child, or she can even change her estate documents if that's her intent. If that's what she wants, she's in control. And a lot of times the other children say, well, that's not fair. She's making a distribution to this one individual and not to us. She wouldn't want that to happen, is always what I hear. She would not have wanted this scenario to occur. Okay, but I have to explain to a lot of times to the clients that it is your mother's right. And unless you can meet this, it's a very high standard to show that there was undue influence on the individual, meaning that it's a high standard that you have to meet. There's undue influence at the time that the transaction occurred to show that she was either incompetent or undue influence. Then you're not going to be able to change or make adjustments to this. Now, sometimes the children will say, well, we want to get this individual out because we think that they've been influencing the mother such in a manner that it's detriment to her detriment. As long as the mother has the right to decide, that child can stay in the property. As long as she's competent, she can say, yes, I want them to be there. But even after a mother decides, okay, I'm agreeing with my other children, maybe there's some issues going on here that I don't quite agree with, and decides that the spouse or that one child should be leaving the house, because that person has been living in the house for at least a year, that individual has a right. She becomes a tenant to the property and has a right to stay in the property for at least 60 days until 60 days after she receives notice to vacate the property. So you can't just tell the child, leave. You've got to get out of here. Or the mother, even the mother can't even say that you need to leave or get out. That child has received a right to stay in the property. That's her home. She becomes a tenant. And if it goes beyond that 60 days, then you have to go through what's called an unlawful detainer action to try to get the child out. Okay. Now, continuing on the scenario, let's change it a little bit. Okay. Where previously we had the one child that was taking care of the mother, the other children disagree with what that child is doing. So one of the children then comes over and takes the mother, brings them over to their house, physically removes her. First off, she invites the mother to come over and stay, and the mother says, sure, I'll come over. And then she stays there. And then that child then convinces the mother that she ought to be staying here, that she could be better provided for if she would stay with this other child. Now, in these type of situations, the first child that was taken care of, they get all offended. They say, wait, this is not what mother wanted to do. She wanted to be staying in her own house. She wanted to be staying here. What rights do I have to bring her back, that she comes back to this house? Well, unfortunately, as long as the mother is competent, she has no rights. The other child has no rights to try to force her to come back to the house. If the mother says that she wants to stay at the house, that's what the law will enforce. Okay, what rights did so that child has no rights to try to enforce to bring the mother back. So what can the children do? Well, they need to accept that if competent, that the mother's decision matters. It's whatever the mother decides, then that is what's going to control. The problem is that the mother will not want to offend any of the children, and will want to stay with whichever person is providing her, yes, the most assistance, but is most loving to her at the time. So what do you need to do? There needs to be done preparation. Although the mother can change it, there needs to be some preparation of the state documents. Yes, the mother can change it, but at least it gives an indication what the mother wants to have occur. And it requires, and for it to be in place, usually requires that there be some incompetency, and requires a doctor to help to support that. So, in conclusion, I think I'm about over with here. To avoid many of these different problems and different scenarios that we have, you need to communicate, you as the individual needs to communicate with the family on what do you want to have accomplished, and get it in writing. Put it down in writing so that you can express what your intent is. Have an up-to-date estate plans. When I talk about estate plans, a will, a trust, powers of attorney, healthcare directives. Review your assets to see how are the distribution of those assets going. Your 401ks, your different bank accounts, how are they being distributed out? And see who is going to be in control of those assets. Is that what you want to have? Is that what the elder wants to have occur? And finally, I always tell all of my clients that if there's assets that you're no longer using, if you don't use these assets anymore, give them away. Give them to your children. Give them to the ones that you know, so there's not going to be a fight over these assets. First off, it saves on Christmas presents by giving them away. But it also, you can see the individual enjoying the asset or the gift, whatever it is that you have. If you're no longer using the item, give it away, and it'll be helpful. So Thank you. I mean, I will open this up to any questions that you have. Yeah. So a guardianship, okay, so guardianship is for minors. Okay. In California, other states treat it differently. In California, a guardianship is a minor, where now it's similar to a conservatorship. Okay. As a guardian, then if there's assets for a guardian, then the courts will oversee that and make sure that there's accounting that has to occur every year, and that the guardian ad litem, the person who has the right to control it, will be receiving the benefits or receive notice of it to make sure that the assets are used out. Yeah, Ollie? So again, they don't have a will, they don't have a trust, they don't have a power of attorney. Then you're falling in, and they have title to assets that are going on. That goes under then the scenario where you have to get a conservatorship. So it becomes, yes, you can get it, but it's going to take you some time, and it's going to cost you a little bit of money to get it. Yeah, right here first. Yes. A trust, yes. So typically in a packet of trust, I mean, they range in value dependent upon if you're using a law firm versus getting it on the internet versus other things that go on. I wouldn't suggest the internet. Only I've had to deal with a lot of trusts on the internet and the problems that accrue, and then we have to enter into some litigation, and it just gets more expensive. Usually they cost anywhere from $3,000 to $4,000 to get what's called a packet, which would include wills, the trust, durable powers of attorney, and advanced healthcare directives. To the time frame to create those documents, usually I can get them done within a week to 2 weeks. And then, but I find that the issue is trying to get the client to review the documents and then getting them in to sign it. So that can take a little bit longer. Right here, first. Okay, so APS, once a child, if a child calls APS, all that they're doing then is coming to check on the welfare of the individual. They will check to see, first off, are they safe? And then they will ask them, do you want to be here? Are you okay to be here? And if the mother says, yeah, then they will do nothing. Okay. So you need to look at what is a significant event that occurs in your life. If someone passes away, that's a beneficiary, then you want to look at that, review that. If you no longer have confidence in an individual, then you want to take a look at that. So that's typically what I explain to my clients, is that you look for a significant event. If you have a child, sometimes you want to look at it if you have another child that goes on. It just what significant event that would maybe change that. Usually if you have a trust, you can transfer assets into it very easily. You just tell the title company, I bought a new house. I've got a trust. I just want this to be transferred over here. And the title company, so you don't need to be updating it each time you have a new asset that comes in. It's just the significant events as to the beneficiaries or the people who are in control, called the successor trustees, that are going to be, that you're having to work with. If they are developing dementia themselves, or can't control their assets, or you don't have confidence in them anymore, then you want to make some changes to your trust. Yeah. Okay, so again, there's several different types of trusts that go on. Okay, under the scenario that I was just proposing here. So a trust is created once you sign the document for the trust, and you fund it. You put assets into the trust. If the trust is such that where one spouse passes away, it will become irrevocable as to half the property. That's typically what the trust will have. Okay. And the surviving spouse will be able to control the other half and can do whatever they want, can change it, can amend the trust only as to that other half of the property. When the second spouse passes away, then it becomes totally irrevocable. It cannot be changed. It can't be altered. And the trustee has to abide by what the terms of the trust state. Yeah.
Not so much a question, but more a comment on the financial side of things. Just as you said, it is so important to get all these things done before these events occur.
Mm-hmm.
It's also so much more helpful to have it all done on the financial side where you already have provisions to care for them. All those things are already stipulated and done. It makes it so much easier.
Yeah. Okay. Yeah.
When you do have like a will and a trust, if there's anything that's not an agreement between those documents, how do they determine?
Okay. So typically, if you have a trust, you typically will have what's called a pour over will, which all that says is that if there's an asset that has not been transferred over to the trust, that happens all the time with either cars or sometimes their bank accounts or other things that go on. If there's an asset that hasn't been transferred over, then the will says that they want it to be transferred to the trust. The trust is the beneficiary. The trustee is the beneficiary. So there's not really an incongruency that's there. Now, if there is an incongruency, if you do have where the scenario would be that you have a trust that says one thing, that the assets are going, but you have, and the will does not say that. The will doesn't say that the beneficiary is the trust, but it's not a pour over will, but it specifically gives assets out. The will only control those assets that are not inside the trust.
The trust would supersede.
No, the trust controls those assets that have been transferred to the trust. So that's why you have to take a property and transfer it to the trust. The trust then controls it. It's no longer part of the will. It would no longer be part of the estate. So but the other assets that are not, that all probate does is the idea is you're transferring title of an asset over to whomever is legally to receive it. So under a will, the will only would control like a bank account that doesn't have anybody else as a beneficiary, or if it's not named in the trust, or vehicles, or sometimes personal property. A lot of times there are houses or other things that aren't in the trust that would then be controlled by the will itself. And that has to go through a probate process.
They put most of their current assets in the trust, like
Yes.
vehicles.
Yes. So what we try to do on our side, we try to get the estate such that it is lower than $184,000. That $184,000 is considered a small estate if it's below that. And so if you transfer like the house, the bank accounts and anything, so that all that's remaining is maybe some vehicles, or so whatever assets are less than $184,000, then we can transfer that after 40 days by a declaration. It's considered to be a small estate, and you can declare that you're the beneficiary, and then the bank account, if it's a bank account that was omitted or whatever, the bank will then is required to transfer that over to whomever the beneficiaries are. So as long as it's less than $184,000 total, then you're fine. We can get it transferred over fairly quickly back to the trust. Yes, because if you have a trust, okay, the will say that it is to be transferred to the trustee of the trust, whoever that trustee is, and a trustee will have successor trustees that will be named, whether they're children or they can be appointed by the court. Yeah.
Widow sell property, and they had a little supermarket on my trust.
Mhm.
Right? And we had and the property listed the trust, luckily, but what happens if it's not your trust? Does it go to probate?
So, okay. So the problem that you have is that there are some provisions that under the law where it says if a property is specifically identified where it's clear, then we can go through a process what's called a Hegstead motion that says that if you have declared it in your trust and you've outlined it and identified it in your trust, and you've got to be clear what it is, then we can go to the court and say, look, this was forgotten, but they had a declaration in the trust that said it was to be transferred over, but they didn't do it. We have a procedure that can go through, and it usually takes about 3 months to get through, going through the court, but we can get that property then transferred into the trust per se. If it's not clear what the property is, such as they say any or all, the courts typically don't like that. I mean, you've got to be specific on what it is that you're transferring over. Okay, so I can't go to the court and say, all right, the provision of the trust said any or all real property has been transferred over to this trust. I go to the court and then they say, well, okay, no, you're not specific enough. It hasn't, you have to make a declaration that yes, this is the property that you want to be transferred over. So in those types of, that's where we get into some problems with the online or the internet trust creations. Yeah. Okay. As the beneficiaries, if you're a beneficiary of the trust, okay, you have a right to get an accounting of the trust every year to see how they're administering it. If they're not following the guidelines of the trust, or you get the accounting and see some fishy type of things going on, okay, you can make a petition to the court to have the trustee removed, and that somebody else be put in that place. But it's up to the beneficiary to be, it's their onus to be watching it and to monitoring it. A co-trustee, yeah, same co-trustee. If another co-trustee is not doing it, they have a fiduciary duty. And so if the co-trustee is saying that no, this person is not using the trust funds as directed, then first off, they need to write a letter, need to be outlining what's going on improperly, but then they can petition the court to have them removed. Okay, any questions, or am I out of time now? Okay, all right.
So good. Obviously, a really hot topic, and just lots of great depth of information. Thank you so much, Jeff. Okay, let's do some raffles. Turn on the lights. I don't know how to turn them on. Okay, anymore. All right.
Do this one first.
Okay, what do we got here? Some like a plant and some little gadgets. Okay. I'm sorry. Roxanne Parker.